The broadcast is now starting. All attendees are in listen-only mode.
Hello, and welcome to our government contracting webinar series, summer of 2017. This is Jennifer Schaus, and thanks to all the attendees for making time to join us today and throughout the series. Today we are joined by Christoph Minarczyk, and he is going to be talking about bid protest, which is a hot topic in government contracting, and he will share some insights with you. As I mentioned, this is part of a series of 7 weeks of complimentary government contracting webinars. The full schedule is on our website under the webinar section, and all of the recordings are listed there the following Monday. The Monday of next week, you'll have all of the recordings from this week, and last week's recordings are on there as well. About my firm, we are based in downtown Washington, D.C., and provide various services for government contractors, most notably GSA schedule services, 8A certification, proposal writing, capability statements, market analysis reports, and so forth. Additionally, we do host networking events, various seminars, as we're doing today, educational webinars. You can sign up for our newsletter, which is complimentary, and that will keep you abreast of all of the events, seminars, and webinars that we host. A little bit about me here, which is not as important as our speaker today. As I mentioned, Christoph Minarczyk, who will be discussing bid protest. So I'm going to hand the controls over to Christoph and let him tell you a little bit about himself, his law firm, and then we'll dig into his topic. So Christoph, it's all yours, and thanks again for joining us today.
Thank you very much, Jennifer, and howdy to everybody out there that is tuned in. So my name is Christoph Minarczyk. I'm the owner of ChristophLLC.com, a consulting firm. I wear a lot of different hats, so I teach professionally government contract law, bid protests, and other topics. I publish articles. I serve as an expert witness in government contracts litigation, and then I also act as a consultant as well. And then in my full-time role, I'm the Director of Policy and Acquisitions at a defense contractor, and I'm also the Senior Policy Advisor for one of our DoD clients in the Office of the Secretary of Defense, Office of Small Business Programs. So you might be wondering, when do I sleep? The answer is I do not sleep. And I'll tell you one thing, before I go to sleep, I read 2 things. That would be the King James Version, and of course, our favorite document, that set of regulations we're all familiar with, the Federal Acquisition Regulations, or the FAR. But my website is at ChristophLLC.com, and you can email me at Christoph@ChristophLLC.com. So let's get into what we're here to talk about, bid protests. Now, this is a really hot topic because you, the contractor, the incumbent, can actually get an extra 6 months of work, of services, and revenue from your client simply by protesting within a certain timeline. Now, this is called the automatic stay or the automatic freeze. Now, the bid protest overview, where can I protest? You got essentially 2 big venues. That would be the GAO, the Government Accountability Office, or the Court of Federal Claims. In this presentation, I'm going to be focusing on the most frequent, the most common bid protest venue, which is the GAO. What I need to remind you of is I am an attorney, but this is not legal advice, and I'm not your attorney. Let's move to the next slide and talk about what this SICA Stay really is. The SICA Stay strikes fear into the heart of every contracting officer. And indeed, during my time on the contracting officer federal side of the fence, it certainly struck fear into my heart. It's about the Competition and Contracting Act. That is the statute that requires full and open competition for procurement. Now, the Federal Acquisition Regulation in FAR Part 33 is implementing that statute, and it has to do with protests. If you protest within a certain timeline, by virtue of the fact of the Competition and Contracting Act, you, as the federal contracting officer, you must essentially freeze your new acquisition, freeze your new procurement. You must suspend or terminate any action that you've been taking. So this is why this is such a problem for the government side. If you, the contractor, protest, it can actually cause a freeze in the timeline so that they can't move forward. Well, here's the bottom line. If the government can't move forward with the award of a new follow-on contract to your competitor who just won, well, chances are the government is going to extend your contract based on an emergency services clause they have, because if they're frozen and they can't move forward, they still need the work done. So what that translates to you quite often is you get an extra 6 months of work while you worry about how to handle that actual protest. So this is a protection, again, from statute, from the SICA statute, and it's essentially putting teeth. It's putting a penalty, or really kind of like a protection against a protest that's filed within a certain timeline, so the government can't just ignore your protest and move on and give the award to your incumbent. So let's talk about this timeline. When the agency receives notice from the GAO that there was a protest filed, it's within 10 days after contract award, or within 5 days after the date offered for a required debriefing, whichever is later. So if you notice, the 10 days is going to happen no matter what. The real variable here is within 5 days after the date offered for required debriefing. So if we look in the next slide to FAR 15506A, it gives guidance to the government that the post-award debriefing, and as you recall, a debriefing is where you sit down with the government and you basically talk about how and why you lost and how and why you can give a better proposal in the future. The government's guidance is to provide this post-award debriefing within 5 days after award. And notice that they say should, not shall. The reason that they say should and not shall is because they don't want to force the government into a premature debriefing that they're not prepared for, because that creates an even greater risk of a protest. But the reason that they want to encourage the government to do it quickly is the same reason the lesson I'm teaching you today about the SICA Stay. After the 5th day following award, the government will be extending your window of opportunity as the incumbent who is going to protest. They'll be extending your window of opportunity to trigger the SICA Stay. So let's talk about the Serenity Prayer. We want to accept the things we can't change. That would be the 10-day limit. Can't do anything about that. And then we want the courage to change the things we can and the wisdom to know the difference. So the wisdom to know the difference would be the only thing you can control as the contractor is really those 5 days after the debriefing date offered. So let's consider our game theory constraints. The rules for when a contract is awarded by the federal government using appropriated funding, the government, they have 3 days to notify the losers. So technically they don't have to tell you that you lost on the same day that they make notice of the award to your competitor. So you as the incumbent could actually be notified 3 days after the award. And then in turn, after you are notified that you lost this follow-on contract, you then have 3 days to request a debriefing from the government. If you don't request the debriefing within 3 days, it's not a mandatory debriefing, and the government doesn't have to give it to you. So you really have to watch that 3-day timeline, because you have to force a mandatory debriefing in order to trigger this SICA Stay. And remember, the SICA Stay is 5 days after a required debriefing offered. So let's move to the next slide. Let's go over an example. Day zero. Day zero, you're the incumbent contractor. You have your $10 million contract. You were certain you were going to win this follow-on, but instead, on day zero, the government awards to your competitor. Bad news. Well, the government waits 2 days. They don't wait until the 3rd day, but they wait until day 2, and they notify you that, sorry, you have lost this competition. You now have 3 days after your notification on day 2. So you take until the 3rd day, and on day 5, you request a debriefing. In turn, the government offers you a debriefing on day 8. Well, let's count it out. The government offered you a mandatory debriefing on day 8. Day 8 plus 5 days, according to the SICA Stay timeline, brings you all the way out to day 13. So remember, it's 10 days after award or 5 days after required debriefing date offered. Well, congratulations, because the government waited those extra days to notify you and gave you the opportunity to have a later debriefing. You now experience 3 extra days that you can trigger this SICA Stay protest. Now, I want to remind you, we're talking about a timeline to trigger the SICA Stay. We are not talking about the timeline to actually file a protest. We are only specifically talking about a timeline that qualifies as a timely protest and also triggers this automatic SICA stay, which could potentially get you 6 months of extra work as the incumbent. So let's move to the next slide and flesh this out. I want to emphasize that it is the date offered by the government, so you can't really game the system. So let's look at this example, day 0. Government awards to your competitor. Again, the government waits 2 days for some reason to notify you that you lost. You wait until the 3rd day. You request a debriefing. It is a mandatory debriefing. You got there within the 3 days. Now, the government offers you a debriefing on day 8. You try to be tricky, and you say, oh, day 8, I can't do that. I'm busy. The only day I could do it is day 13. Well, I have some bad news. That sort of gamesmanship will not help you. It does not change the actual timeline. The timeline will be the exact same as the previous slide because the government offered it on day 8. So there is a rule here where we are not rewarding you for kind of delaying the onset of the actual debriefing date. So that won't help you out. But let's talk about what will help you out. Next slide of game theory optimal strategies. So I'll tell you what everybody should do, and you should change your behavior accordingly. On day 0, the government has every incentive to award and to notify offerers on the same day. When I was on the federal contracting officer side of the fence, that's what I always did because I always knew about this strategy. Any day that the government extends, if they say notify you as a loser on the 3rd day, that is not a good idea for them because they are stretching out the timeline for when they could potentially give you the offer for the mandatory debriefing. Now, here's what you should do. As the contractor, it sounds counterintuitive, but when you get the notification that you've lost, you actually should not ask for the debriefing immediately. A lot of people do this, but if you are trying to maximize your window of opportunity to trigger the SICA stay, to potentially give yourself an extra 6 months of work as the incumbent contractor who has just lost to the competitor, you should actually wait the full 3 days because then you will extend the timeline. It will extend the window of opportunity for you to potentially trigger this SICA stay. So again, really important lesson. When you get that notification that you've lost the follow-on competition, you should actually wait until the 3rd day to request the debriefing. Okay, so next slide. If everybody is playing their cards right, if both the government and you, the contractor, do everything that you should, and you have a game theory optimal strategy, the government is going to award and notify the losers on day 0, same day, and then you're going to be really cagey as a contractor. You want to keep your options open, so you're going to wait until the 3rd day. Well, what this forces the government to do in the game theory optimal strategy, if you do everything you should do and the government does everything they should do, this puts the government in a tough spot where they must be ready to offer the debriefing on day 4 or day 5. Any other choice is extending your window of opportunity to trigger the SICA stay and potentially give yourself 6 months more work, right? Because if they offer it on day 4 or day 5, 4 plus 5 is 9, 5 plus 5 is 10. That's the same as the traditional 10 days after award, so no change, right? But if they offer it on day 6, 6 plus 5 is 11. If they offer it on day 9, now you got 14 days, right? So you are extending your time to talk with your general counsel, to strategize with your CEO, to talk to the business development team, and to think about how and if you are going to actually protest this award. It gives you more time to hire an attorney or talk with consultants to determine whether or not it's a good idea to protest. So the next slide, what I advise you to do, always write a timeline, mark up a calendar, create a chart, do whatever you need to do, but you need to have a game plan. This should not come as a surprise to you. You should immediately know what days are day 0, when the government should be notifying you that you lost, and you should be certainly tracking how many days you have to ask for a mandatory debriefing, and you should also immediately understand your options to extend the window of opportunity for the SICA stay or the automatic freeze. Now, one little tricky point I want to add, the definition of a day. There are many definitions throughout the federal acquisition regulation. Everybody knows the basic definitions. The common definitions are in FAR Part 2. But if you're in a different part of the FAR and there's a specific definition, that's the definition that you use. So when we're talking about mandatory debriefings, we are talking FAR Part 15, and that directs you to a definition found in FAR Part 33, protests, disputes, and appeals. I want to point out, definition of day is different for these GAO protests. It is a different definition than the common one that you'll find in FAR Part 2. The holidays and the weekends matter. It's not just calendar days. All right, so definition of day, if we go to the next slide, if the government notifies losers on a Friday, Monday is a federal holiday, you actually have until Tuesday. So if you were using the common FAR Part 2 definition, which would be a mistake in this case, you wouldn't get that answer right. You have to read into the FAR and notice that you're using the FAR Part 33 definition, which does not count federal holidays or days that the government is closed or weekends if that is the last date of a deadline, which this certainly is all about, a deadline. All right, now let's talk strategy. Should you actually protest? I want to stress what I'm teaching you in this presentation is the sheer mechanics. I'm teaching you the strategy of the timeline that could potentially freeze the contract, forcing the government to give you an extra 6 months of work. I am agnostic on other variables, but those other variables are extremely important. The decision to protest or not is extremely important, and one of the biggest considerations will be the client relationship, because of course the federal government will probably not be happy if you trigger the SICA Stay and you cause them to instead give you an extension of 6 months, right? There's many other considerations like that. I can't go into that in this type of a presentation. I'm only giving you the basic facts, and I'm allowing you to make those decisions on your own business judgment. So let's talk about the numbers, all right? Let's run the numbers. If we go to the next slide, cash flow is the lifeblood of any business. So think about it. If the SICA Stay, the automatic freeze, forces a 6-month extension of your contract, and by the way, the mechanics of that, most service contracts will have FAR 52-217-8 option to extend services. It allows up to 6 months of an extension for emergencies such as, oh, there is now a bid protest at the GAO that we must adjudicate. That's why the clause is in there. So you're forcing them to activate or exercise this option to extend services. Now, if we move to the next slide, let's just talk about a very small service contract, just a couple of full-time equivalents, just a few people on the contract. Let's say that it's $5 million over 5 years. So we're talking $1 million per year. Now, if you trigger the SICA Stay as the incumbent and they activate the option to extend services for 6 months, you're getting roughly $500,000 in revenue. Now, that's not profit, but that $500,000 in revenue is going to allow you to keep the lights on and to meet your payroll, and it might be the life support you need for your small business to survive into the next fiscal year. Now, if you consider that a bid protest, let's just use a, rough number here. Let's say that it's, slightly over $100,000. Sounds like not such a bad trade-off at all. $100,000 for $500,000 of revenue to keep your company alive almost seems like a no-brainer. And keep in mind, this first example is a relatively small service contract. If we go to the next slide and the next example of a larger service contract, $50 million over 5 years, if this is a $10 million a year contract, only based on the numbers, not based on the client relationship, it is a no-brainer. If you trigger the SICA Stay as the incumbent, you're going to get an extra $5 million in revenue based on a bid protest that is only going to cost your company roughly, $100,000. Say it's even more. Say you get one of the most expensive attorneys around. It's still going to be worth it for you to get that $5 million in revenue. So I'm going to tie it all together. What did we talk about today? It's called the SICA Stay for the Competition in Contracting Act. That is a statute that requires full and open competitions in every federal procurement, and one of its provisions says that if you protest to the GAO within a certain time, the procurement will be frozen. It cannot move forward until that GAO protest is adjudicated. Now, for you, that gives you an advantage as the incumbent. You can protest if you lose to your competitor in a follow-on contract, and then you can force the government to activate the option to extend services clause, which essentially is giving you an extra 6 months of work, an extra 6 months of revenue, and some time to potentially salvage your business and the client relationship. So again, I'm agnostic on whether or not you should do that, but I'm just giving you, the theory and the mechanics behind it. And it will be up to you, your general counsel, your CEO, and anyone you hire to advise you to determine if a protest is indeed a good idea for you in that particular situation.
Outstanding information, Christoph. Thank you so much for sharing your insight, your expertise, and your thoughts on bid protests. This session is recorded, as they all are, and you'll be able to find the recording on our website under the webinar section at the latest Monday of next week. It should be there maybe Friday or over the weekend. Any questions, please direct them directly to Christoph. His phone number and email address are there. Again, thanks everybody for joining us today. Tomorrow we're talking about grants. Thursday is proposal writing, and Friday is pipeline. So thanks again, everybody, for joining us, and hope you'll join us later this week.
Thanks, Jennifer.
Thanks, Christoph.